Hello, my name is Nils O'Donoghue and I'm a partner here at Chadwick Lawrence in our regulatory and crime team. We advise businesses here at Chadwick Lawrence, but we also advise individuals who find themselves with regulatory or criminal issues. The most common type of case that we deal with are what is known as totters. A totter is someone who's accrued 12 or more penalty points. What this means is that you'll be invited to court as the court is thinking of disqualifying you from driving for at least 12 months if you have 12 or more penalty points on your licence. It may be that actually you've been in hot water before and have been banned from driving. If this is the case, then it may be that the court will impose a ban in excess of 6 months. The minimum period for a totter, which is an individual with 12 points or more on their licence, is a 6-month driving ban. There is, however, an argument that can be made at court to avoid a driving ban, and this may be that the court accepts this argument and doesn't ban you at all, but the penalty points remain on your licence, or rather rarer, imposes a shorter ban than 6 months. So I have seen it in the past, albeit, as I say, on rare occasions, where what is known as exceptional hardship is found and a ban less than 6 months, for say 28 days, is imposed on a particular individual. Usually, however, if you do put forward an argument of exceptional hardship, then the ban will not apply at all. Exceptional hardship is the only way, generally, to avoid a totting ban. What exceptional hardship is exactly what it says on the tin. It must be hardship caused to a person which is exceptional. And in our experience of doing these cases over the last 7 or 8 years in local magistrates' courts, it's usually hardship arguments that apply to a person other than the person that is facing the ban that are most likely to tug on the court's heartstrings and make them find exceptional hardship if they have the ability to do so. There are some arguments that they will simply be not interested in. So, for example, if you were to go to court and say that you would lose your job if you are banned from driving, the guidance is quite clear that that is not enough. You must go that extra step, and show to the court why losing your job would affect another person, for example. So it's important that you do go to court prepared and with legal representation. We go to court regularly on these types of cases, and I see people try and do these cases on their own, and because they don't have the knowledge or presentation skills, they are often unsuccessful. So it's important that you focus on hardship that is exceptional and generally hardship that is going to affect someone else. So in terms of the arguments that you could raise, you've got to think of key arguments and present those and make sure that any arguments which you know that are not going to interest the magistrates are left out so the focus isn't taken from your stronger arguments. So the questions that I would ask myself if I was facing a 6-month ban is what exceptional hardship arguments do I have? So would you lose your job if you could not drive? Remember, that is not going to be enough, so you need to go beyond that. Could you take public transport or taxis to work? Could you hire a private driver? The court will expect you to have answers to those questions as to why you couldn't do those things, because a ban ultimately is designed to be a punishment. So mere inconvenience is not going to be enough. And if you can use those alternative transport forms or afford something like a public transport driver, then the court will expect you to do so. If you are going to lose your job, would that job loss impact on your colleagues or your family members? So it might be that an exceptional hardship argument would be that you are so important to a business, such as a managing director or a sales director, that if you did lose your job, you would actually mean that in your workplace that would be affected, and there may be redundancies, for example. You could argue that your family could also be affected by the loss of your job. So if you lost your job, would you be unable to afford your mortgage, which would render your family homeless or have to seek alternative accommodation? How would others be affected if you couldn't drive? Do you look after an elderly relative? Do you do charity work? These are the types of arguments that the magistrates are receptive to. Do your children rely on you to drive? It's these types of arguments, as opposed to going into court and focusing on yourself, that are likely to be found to be exceptional hardship. The examples that I'm given are just food for thought. There's a myriad of different examples, and we've seen some very left field examples be successful in court. and that's because presentation plays a large part in these cases. Hopefully you never find yourself in the position where you are facing a 6-month driving ban, at least a 6-month driving ban as a totter. But if you do, hopefully this video has helped with the types of arguments that we would look to present in court. And if you do find yourself in this position, please do not hesitate to get in contact with us. I'd like to take this opportunity to thank you all for your instructions in 2022 and wish you and your families a safe and very Merry Christmas. Thank you.